Hey there, welcome back to Help Solve the Case. We are continuing our part two review of the state's update to the preliminary hearing for Tyler Robinson's case, the murder of Charlie Kirk. I was just trying to make sure I got all of that out. We did part one of the state's response. We had the earlier part of the preliminary hearing. All of those videos are here on the channel. And the state filed a brief. We are waiting for the defense's brief. And then we've got our hearing on September 1st. And I want to let you know, I was playing around with the measuring cup in the first video, and I managed to get it all over my shirt. That's what happened. It's pretty dangerous here in YouTube land. But we're going to continue doing part two. And I want to thank you all for being here, for supporting me and learning all about this stuff. I appreciate all the comments and everything, how we can apply this to all the cases. All right. We left off here where the state is taking us through each element of the crime. If you're not aware, when we have a crime, the crime is delineated by elements. You have to meet each element. And since we're talking about cooking, all right, if you're going to make chocolate chip cookies, for example, each element of the chocolate chip cookie would be flour would be one, butter would be one, chocolate chips would be one, eggs would be one. What is it? Oil or water, whatever goes in there. All of those would be the elements that you would come up and end up with chocolate chip cookies. And if you didn't have the chocolate chips in there, it would not be a chocolate chip cookie. It would be a cookie, but it wouldn't be a chocolate chip cookie. With this charge here, we have intentional unaliving, for example. And if the intention isn't there, the chocolate chips, then we may have a lesser charge. And that's why the state is going through and walking the judge through all of the elements. And it helps us articulate all the elements that the recipe for these charges to meet the state's burden in the information. The recipe, he's giving us the recipe for the charges that they've put on Tyler Robinson to bind him over for trial. We're here on this part. Defendant also knowingly created a great risk of death to everyone near Mr. Kirk when the defendant pulled the trigger. And I believe, I don't remember exactly, that's an enhancement, and they're going to elaborate on that. Defendant also knowingly created a great risk of death to all others who were near Mr. Kirk, but not within the line of fire when defendant fired the fatal shot. They're talking about a case here, Sosa-Hurtado, establishes that firing a gun at one person can create a great risk of death to others who are near, even if they were not in the line of fire. I had to sneeze. I'm just having a day. Sosa-Hurtado involved a murder in a small smoke shop. You guys know me with this alliteration. A small smoke shop where a father and son worked. After Sosa-Hurtado repeatedly refused the father's demands to move his car because it was endangering customers, the son intervened and again asked Sosa-Hurtado to move his car. That's weird. I don't think that makes sense because it says Sosa-Hurtado refused the father's demands. Maybe Sosa-Hurtado was not the family. I was confused there. I think I got it now. The son intervened and asked Sosa-Hurtado. Sosa-Hurtado must have been a customer or some other person. Asked Sosa-Hurtado to move his car. Sosa-Hurtado responded by punching the son and starting a fist fight that Sosa-Hurtado ultimately lost. Sosa-Hurtado left, but later returned with an assault rifle and fired one shot at the father, who was standing behind the counter 2 to 4 feet away from his son. The first shot missed the father and hit a glass case, sending glass and wood into the father's leg and causing him to fall to the floor. Sosa-Hurtado then turned towards the son and fired a second shot that hit the son's hand and caused him to also fall to the floor behind the counter. The father began to get up and move towards his son when, quote, with his back to father, Sosa-Hurtado leaned over the counter, positioned the rifle only inches from the son's chest, and shot him twice more, end quote, killing him. Quote, the smoke shop consisted of a single room approximately 15 feet wide and 24 feet long. I'm not getting the analogy here. Are you guys getting it? I'm not getting it. Because he shot them both. After a jury convicted Sosa-Hurtado of aggravated murder, he appealed and challenged the sufficiency of the evidence, that could be probable cause, to support the charged aggravating factor, quote, that he placed another person at, quote, great risk of death, end quote, when he killed his victim, quote. The Utah Supreme Court had no trouble rejecting the argument and affirming the aggravated murder conviction. The court found that, quote, two separate acts, end quote, each, quote, created a great risk of death to the father, end quote. The first was the shot directed towards the father, but, quote, the second was the initial shot aimed at the son, a shot that hit the son in the hand when the father was only a few feet away, end quote. The court concluded that, quote, a reasonable jury could conclude that both of these acts created a great risk of death to the father, end quote. Thus, firing at one person while another is, quote, only a few feet away, end quote, knowingly creates a great risk of death for that other person. Here, in addition to those in the defendant's line of fire, several others were in close proximity to Mr. Kirk when the defendant shot him dead. At least two individuals were standing under the tent where Mr. Kirk was seated, and others were near the front, sides, and back of the tent. As in Sosa-Hurtado, these individuals' proximity to Mr. Kirk when defendant fired them put them in the zone of danger. Their, quote, proximity and spatial relationship, end quote, together with, quote, indirect, end quote, threats to them arising from, quote, the risk of a stray or ricocheting bullet, end quote, put them in the zone of danger, especially where defendant used a high-powered rifle to kill Mr. Kirk. Other courts agree that the risk of stray, ricocheting, and pass-through bullets creates a zone of danger for anyone close to a shooting victim. For example, in Commonwealth v. Rios, the Pennsylvania Supreme Court found that firing the, quote, fatal bullet at the victim while the victim lay on the floor of an enclosed bedroom, end quote, while another, quote, was on the floor close to the victim, end quote, and others, quote, were on a bed nearby, end quote, created a great risk of death to everyone in that bedroom. The Rios court recognized that, quote, an errant bullet could have struck and killed, end quote, anyone in the bedroom. That, quote, risk of death was not reduced because Rios fired only a single bullet, end quote. Quote, it is not necessary that the endangered bystander be directly in the line of fire for a grave risk of death to occur, end quote. What does it say in the state where you live? Indeed, the Pennsylvania Supreme Court has repeatedly confirmed the conclusion that a zone of danger encompasses everyone near a shooting victim. Quote, in a day and age where accidental victims of shootings are prosaic, a jury can infer that an individual is, quote, knowingly endangering a person when that individual uses a gun in any area where he knows that others could be, end quote. I'm thinking about drive-by shootings. I'm thinking that this probably came about and gained prominence from drive-by shootings where someone else died and they didn't intend, they might have said they didn't intend to do that. They were trying to shoot up a house or do this, that, or the other, and somebody else died. We see it so unfortunately. And they said the jury properly found that the defendant created a, quote, grave risk of death where others were in danger of being struck by an errant, ricochet, or, quote, pass-through bullet. As with those in the line of fire, defendant also acted knowingly in creating a grave risk of death for all those close to Mr. Kirk when defendant pulled the trigger. Again, defendant could see, especially through his rifle scope, those who were in front of and to the sides of Mr. Kirk. It is also reasonable to infer that the defendant could see people in the area behind Mr. Kirk's tent. In fact, earlier that morning, defendant had been down to the amphitheater area, interacted with some TPUSA representatives, and would have seen firsthand the staging area behind Mr. Kirk's tent. Defendant was thus, quote, aware of the existing circumstances, end quote. That is, that several people were near Mr. Kirk when the defendant shot him. Again, defendant himself anticipated that he might miss Mr. Kirk. He loaded his grandpa's rifle with not just one engraved bullet, but with 4 engraved bullets. Had he been certain of his aim, he would have no reason to load it with more than 1 bullet. But defendant was well aware that he might miss his target, thereby putting others in danger, both those in the line of fire and others nearby. And he thus came prepared with 4 bullets in the event his aim was not true, a real possibility as his own target practice had confirmed to him. Now, I have a question for you, because I'm not as much in these cases as you guys are, and I don't remember, but do you find this statement by the state compelling? And is there these admissions that they say that Robinson made? Do you think that these 4 bullets were for a miss? Or could they have been for other people? Because if they were for other people, and we're just positing, we're just talking about the legal elements here, we're thinking it out, other possibilities, we're avoiding tunnel vision, could those bullets have been for somebody else? And if so, does that negate this portion of what the state says the defendant knew that he might miss? Just asking. The state therefore presented ample evidence of the aggravating circumstance. This is the aggravating circumstance. Because the evidence demonstrates probable cause for each element of count 1 aggravated murder, the court must bind defendant over for trial on that count. Now, what if, because they talk about his records, that they went and got his target practice records, what if there's an expert that comes in and says, man, this is the best shooting ever, these target practice, even though he sometimes missed his chance, like our DNA, 1 in whatever octillion. What if they said he's got a 99.999999% chance of hitting the target? Does that also negate that aggravating factor? Again, not that we're thinking crazy, we're just thinking possibilities. Because if it's possible, that's beyond a reasonable doubt. That's a doubt. The state has to meet all these elements. That's the way my mind thinks. The evidence establishes probable cause that defendant committed count 2 felony discharge of a firearm causing serious bodily injury. To establish that defendant committed felony discharge of a firearm causing serious bodily injury, the state must show that defendant discharged a firearm in the direction of an individual. 3, knowing or having reason to believe that an individual may be in danger by the discharge of the firearm, and cause, and here it's caused, serious bodily injury to the individual. They talk about Utah code. Here they're saying the same evidence, so go back to the other one, that establishes probable cause that the defendant committed aggravated murder, also establishes probable cause that he committed each element of felony discharge causing serious bodily injury. As explained, the evidence establishes probable cause that the defendant fired a high-powered rifle in Mr. Kirk's direction. As also explained, the evidence establishes probable cause that defendant knew that firing a high-powered rifle at Mr. Kirk would endanger Mr. Kirk. Indeed, defendant admitted that he intended to kill Mr. Kirk. The evidence also establishes probable cause that the defendant inflicted serious bodily injury on Mr. Kirk. Quote, serious bodily injury, end quote, means bodily injury that creates or causes serious permanent disfigurement, protracted loss or impairment of the function of any bodily member or organ, or creates a substantial risk of death. Defendant did not merely create a, quote, substantial risk of death, end quote, when he shot Mr. Kirk, he in fact caused Mr. Kirk's death. The evidence therefore establishes probable cause that defendant committed count 2. The evidence establishes probable cause that the defendant committed counts 3 and 4, obstruction of justice, by concealing or removing both the firearm he used to shoot Mr. Kirk and the clothing he wore during the shooting. And I'm going to add in this video, because I know we talked about it in the first video, using our measuring cup, we are only at probable cause. We are not at 100% beyond a reasonable doubt. We are only at an eighth a cup. To establish, let's see, the evidence that he committed counts 3 and 4 by concealing or removing both the firearm he used to shoot Mr. Kirk and the clothing he wore during the shooting. To establish that the defendant committed obstruction of justice, the state must show that defendant, with intent to hinder, delay, or prevent the investigation, apprehension, prosecution, conviction, or punishment, that's a long laundry list there, of any person regarding conduct that constitutes a criminal offense, and destroyed, concealed, or removed an item or other thing. The evidence establishes probable cause to support each element. Thus, says the state, defendant admitted to Mr. Twiggs that he had concealed his rifle by leaving, quote, it in a bush where he changed outfits, end quote. UVU surveillance video also shows defendant moving both towards and away from the wooded area north of campus where investigators found his rifle. As for his clothing, consistent with the defendant's admission to Mr. Twiggs, the surveillance footage showed defendant returning to campus just before the shooting wearing different clothing than he wore during his previous campus visits. Defendant also admitted to Michael Mitchell, not sure who that is, that he, quote, discarded, end quote, the clothes, quote, that he wore during the incident, end quote. I don't remember that guy. Is that the family friend? Who's that guy? Sometimes all the cases run together. All this evidence establishes a reasonable belief that defendant both removed and concealed the rifle he used to shoot Mr. Kirk and destroyed, concealed, or removed the clothing he wore when he fired the fatal shot. This evidence therefore establishes probable cause to support these elements of count 3 pertaining to the rifle and count 4 pertaining to the clothing. They've hit him with 2 counts of obstruction, one for the rifle and one for the clothing. The evidence also establishes probable cause that defendant intended to hinder, delay, or prevent a criminal investigation. Defendant texted Mr. Twiggs that he, quote, had hoped to keep this secret till he died of old age, end quote, and that if he were, quote, able to grab his rifle unseen, he will have left no evidence, end quote. There's a bullet. I don't know, there's a bullet. In the note, defendant left for Mr. Twiggs before driving to UVU. Defendant predicted that by the time Mr. Twiggs read the note, defendant would be, quote, likely dead or facing a lengthy prison sentence, end quote. These admissions demonstrate that defendant knew a criminal investigation for murder would follow his shooting of Mr. Kirk and that he intended to obstruct that investigation. At the very least, that is a reasonable inference from defendant's admissions. The evidence therefore establishes probable cause that the defendant committed both counts of obstruction of justice. D. The evidence establishes probable cause that defendant committed count 5 and 6, tampering with the witness, by directing Mr. Twiggs to delete incriminating text messages and not to talk to police. To establish that defendant committed tampering with the witness, the state must prove that defendant either believed that an official proceeding or investigation was pending or about to be instituted, or intended to prevent an official proceeding or investigation and attempted to induce or otherwise cause another individual to withhold testimony, information, a document, or an item. The evidence establishes probable cause to support each element. After defendant made several incriminating admissions during a text exchange with Mr. Twiggs, some of which are described above, defendant directed Mr. Twiggs to, quote, delete this exchange, end quote, and not to speak to police. Defendant's demand that Mr. Twiggs delete the messages establishes probable cause for the first and third elements of count 5. Defendant's first and third, so now we need 2. Defendant's demand that Mr. Twiggs not speak to police establishes probable cause for those same elements of count 6. All right, we're missing number 2, right? Now it says, the evidence also establishes probable cause for the second element of both counts, that defendant either believed an investigation was pending or intended to prevent an investigation. As explained, in the note defendant left for Mr. Twiggs before driving to UVU, defendant predicted that by the time Mr. Twiggs read the note, defendant would be, quote, likely dead or facing a lengthy prison sentence, end quote. As also explained, defendant texted Mr. Twiggs that he, quote, had hoped to keep the secret till he died of old age, end quote. And that if he is, quote, able to grab his rifle unseen, he will have left no evidence, end quote. When Mr. Twiggs stated that he thought police had, quote, caught the person, end quote, defendant clarified that police had, quote, grabbed some crazy old dude, end quote, and, quote, interrogated someone in similar clothing, end quote. Interesting. Defendant also explained that police activity, including an, quote, officer with a canine, end quote, was preventing him from retrieving his rifle. That could be the person at the corner. It was after these additional admissions that defendant directed Mr. Twiggs to delete their text and not to speak to police. The evidence therefore establishes probable cause that the defendant knew that an investigation was underway when he gave those directions to Mr. Twiggs. The evidence therefore establishes probable cause that defendant committed both counts of tampering with a witness. Now we got 7. The evidence establishes probable cause that defendant committed count 7, violent offense committed in the presence of a child. To establish that defendant committed a violent offense in the presence of a child as a Class A misdemeanor, the state must prove that defendant committed criminal homicide as defined in Section 76-5-201 against the third party in the physical presence of a child younger than 14 years old, that defendant had knowledge that the child was present and may have seen or heard the offense, and that defendant targeted Mr. Kirk because of defendant's perception of Mr. Kirk's political expression. The evidence establishes probable cause to support each element, says the state. As explained, the evidence establishes probable cause to support the first 2 elements, that defendant committed criminal homicide. The evidence also establishes probable cause that a child younger than 14 years old was physically present when defendant killed Mr. Kirk. A video from a mother in the crowd shows that she was there with her children, at least one of which was under 14. I think we saw that at the preliminary hearing. Another video shot from behind Mr. Kirk shows 2 women in the crowd holding infants. The 2 women are standing next to each other and can be seen just to the right, just the south of the speaker pole that is visible in the right center of the frame. The evidence thus establishes probable cause for the third element. The evidence also establishes probable cause for the fourth element, that defendant knew that a child of younger than 14 was present. Defendant could see the entire crowd from his rooftop perch. Defendant also made at least 2 visits to campus before the shooting, where he walked around the amphitheater and treated himself to lunch at the Sorensen Center, is that the Chick-fil-A, which borders the amphitheater on the northeast. One reasonable inference from this evidence is that while walking around this area, defendant would have seen many of the attendees who were gathering for the event, including children who were present. The evidence therefore demonstrates probable cause for each element of count 7, violent offense committed in the presence of a child. And I will push back here on a little bit. I want to ask you this question. We heard that there was a video of the two moms with the infant, and then the video from the other mom with the child under 14 that we saw at the preliminary hearing. But this statement here about the entire crowd and his 2 visits to campus where he treated himself to lunch, this is prior to, they're saying one reasonable inference is that while walking around, he could have seen many of the attendees who were gathering for the event, including children who were present. Who's to say that they were going to be there during the event? Who's to say that they didn't come early and go home? Who's to say that there wasn't a library event at the campus and they left before the thing happened? I think that's pretty risky putting that in there. What do you think? That just because when he came earlier, when Robinson is alleged to have come earlier, because he saw a couple kids an hour, 2 hours, 3 hours, 4 hours before, that meets the element of the crime. What do you think? That we have to critically think on that. The evidence also establishes probable cause to support the state's charging count 7 as an enhanced Class A misdemeanor because, here we go, because defendant targeted Mr. Kirk based on defendant's perception of Mr. Kirk's political expression. And I say, here we go, because we had some, what I call tete-a-tete, right? We had some back and forth and a lot of questions. And I did another video on this, specifically referring to this because we had those 1102s from the church person who might be considered a witness or might be considered an expert, but wasn't an expert, talking about the business stuff and who had the burden. The state had the burden or the defense had the burden about Mr. Robinson's mental intent, hatred, and was it political expression or was it personal perception, right? This count is a big deal, and I don't feel that it's resolved. The victim targeting penalty enhancement enhances the crime of committing a violent offense in the presence of a child from a Class B misdemeanor to a Class A misdemeanor. To establish this enhancement, the state must prove that defendant intentionally selected his victim. Hold on, let me go back. I'm confused here. It's about a child being present, but then when it's a personal attribute, there's a child here, but then it turns to a higher misdemeanor because there's a child and a personal attribute. That seems weird that they should be two different, I don't want to say statutes, but two different penalty enhancements. Because I don't know, does that seem weird? That just seems weird because I think you would have one without the other. But they say must show that he intentionally selected his victim. I don't know why it's. I don't know. I'm gonna have to look at that. I don't think the child thing should be here. I'm confused. I don't know. The statements prove that because here it doesn't say the child. It says they intentionally selected the victim because of the defendant's belief or perception regarding the victim's personal attribute. I don't know if they cut and pasted. I'm not sure. A victim's personal attribute includes the victim's political expression. And we kind of went through that list in the statute, and there was personal attributes, and it did talk about religion. So it kind of seemed like it was all lumped in there, but I'm not in Utah, so I'm not really familiar with their enhancement statute. Let's see what they say. The evidence establishes probable cause to support each element of the enhancement. As explained, defendant admitted to Mr. Twiggs that he targeted Mr. Kirk because defendant had, quote, had enough of Mr. Kirk's hatred. Some hate can't be negotiated out, end quote. He also wrote to Mr. Twiggs that he wished they, quote, could have lived in a world where this did not feel necessary, end quote. Defendant in his message did not identify what he believed to be the specific, quote, hatred, end quote, from Mr. Kirk that he needed to stop by killing him. But that is not necessary to prove intent beyond a reasonable doubt, much less to establish probable cause. Quote, specific intent may be proved by circumstantial as well as direct evidence, State v. Jennings. And the circumstantial evidence that defendant targeted Mr. Kirk because of defendant's belief or perception of Mr. Kirk's political beliefs is overwhelming. The defense would have the court believe that Mr. Kirk was only a religious evangelist. He was much more. He was the founder, chief executive officer, and board president of TPUSA, whose express purpose is, quote, to empower informed civic and cultural engagement grounded in American exceptionalism and a positive spirit of action, end quote. As TPUSA's leader, Mr. Kirk helped, quote, citizens, end quote, develop the quote, knowledge, skills, values, and motivation so they can meaningfully engage in their communities to restore traditional American values like patriotism, respect for life, liberty, family, and fiscal responsibility, end quote. And we can see here that meaningfully engage in their communities to restore traditional American values, highlighting patriotism, and then the other things are not there, but family is. I'm just going back here because it says personal attribute, and they are saying it's political expression. What they're describing here, and I don't want to start a war in the comments, I'm just making the question, is this, as they describe it, political, what do they call it? Political expression. Because it says traditional American values. And I don't know what the family. Is it because it says American values? Let's see what they say. To that end, Mr. Kirk, again, we're just looking at the semantics and the elements to show the linkage. To that end, Mr. Kirk would hold events like the one at UVU on September 10th, 2025 to engage, quote, in civil debate and discussion on traditional family values, America's founding principles and political doctrines, end quote, and, quote, to persuade attendees to follow a mindset rooted in politically conservative values, end quote. There we got two political words. Those, quote, traditional American values, end quote, in Mr. Kirk's view are synonymous with, quote, the classical Orthodox Christian position on marriage, family, gender, and sexual being, end quote. That sounds like religion more than political. If we just look at the words. I'm not sure. I don't know. Mr. Kirk believed that, quote, God determines whether a person is male or female, and that experimentation with sexual gender identity is sinful and therefore should not be engaged in, accepted in culture, or allowed under the law, end quote, and that, quote, heterosexuality inside the confines of a marriage is the only virtuous pattern for sexuality, end quote. That seems more, I don't know. The evidence, I'm not saying what they wrote. I'm just saying how to prove this, how to prove which one it is, how to prove which element of, but they're saying this is all political, that this is not religious. They did not say religious. They said this is all political. The evidence thus establishes that Mr. Kirk represented not only a religious movement, but there's the religious word, but also a political movement against gay marriage and the accommodation and acceptance of transgenderism, homosexuality, and sexual experimentation. I don't know the semantics, right? Because it's a legal definition. I don't know. Defendant's lifestyle, on the other hand, stood in sharp contrast to Mr. Kirk's religious and political views. The evidence establishes that, the defendant was like, what? Defendant's lifestyle, on the other hand, stood in sharp contrast to Mr. Kirk's religious and political views. Again, there's that word religious. Should the state, and again, we're not having a debate on religion or politics here. We're having a question. I'm raising the question of, in fulfilling the probable cause element of the crime that stated political, should the state be putting the religious in there? Because they didn't choose the religious one. They chose the political one. Are they shooting themselves in the foot by quoting the religious one? Just asking. Semantics. The evidence established that defendant was in a homosexual relationship with Lance Twiggs. The evidence also establishes that at or near the time of Mr. Kirk's assassination, Mr. Twiggs was exploring transitioning from a man to a woman. And defendant's texts to Mr. Twiggs demonstrate that he loved and cared deeply for Mr. Twiggs. In other words, defendant's beliefs and practices pertaining to gender and sexuality were directly contrary to Mr. Kirk's political and religious beliefs and practices. There they put the religious word in there. And I don't know why they're putting the religious word in there, because they only have to prove the political. Against that backdrop, the evidence establishes that defendant engraved the cartridges in his rifle with several political messages. The spent .30-06 cartridge was inscribed with the word, quote, notices bulge OWO, end quote, a furry meme and reference to male genitalia. One of the unspent cartridges found in defendant's grandfather's rifle contained an inscription referencing homosexuality. Quote, if you read this, you are gay, end quote. And another unspent cartridge contained the overt political reference, quote, hey, fascist, catch, end quote. This evidence supports a strong and eminently reasonable inference that defendant targeted Mr. Kirk because of defendant's, quote, belief or perception regarding Mr. Kirk's, quote, political expression, end quote. The evidence therefore establishes probable cause to support count 7 as an enhanced Class A misdemeanor. 3, the court does not need to bind over on the sentencing enhancements that increase the level of offense. I don't know. It sounds like they don't need to meet the enhancement or the sentencing enhancements. It sounds like those enhancements are only for extra time. But it says, but even if the court did, the evidence demonstrates probable cause to support these enhancements. As explained in the charging information, the state notified defendant that sentencing enhancements for 1, committing a violent offense in the presence of a child, and 2, targeting the victim because of his political expression, could apply to both counts 1 and 2. The court need not bind over on these sentencing enhancements, so that means they don't have to prove it before the preliminary hearing. When I felt that they potentially had an issue, it sounds like that might be okay for now. They do not increase the level of the offense and therefore are not elements of the underlying offense. Rather, they affect only the potential sentence defendant can receive if convicted of the underlying crime. It doesn't really matter now. At a preliminary hearing, the state need only establish probable cause to support each element of the charged offenses, not the sentencing enhancements. But even if the state were required to demonstrate probable cause to support the sentencing enhancements, it did so as already demonstrated. They feel that they've proved those. Sentencing enhancements that do not affect the level of offense are not elements of a crime and are therefore irrelevant at a preliminary hearing. Preliminary hearings are concerned only with the elements of charged crime, not sentencing enhancements. Sentencing enhancements that do not increase the level of an offense are not elements of a crime. The Utah Supreme Court has expressly recognized that sentencing enhancements need not be formally charged in an information. That's interesting. Making me think of cases. In his murder prosecution for shooting his grandfather, they're talking about Schroeder argued that the state was required to allege in, quote, the charging portion of the information, end quote, the sentencing enhancement for his use of a firearm. But the Utah Supreme Court rejected that assertion. The court explained that, quote, while such a technical requirement might be appropriate with respect to the elements of a crime which the state seeks to convict a defendant, we see no purpose to be served in applying it to an element of punishment, end quote. That's interesting, because our indictments usually carry the punishment, and they have to be particular. My mind's going off on a tangent. Quote, the punishment for a crime is not and has never been considered a part of the pleading charging of the crime, end quote. That's Utah. Quote, after conviction, the penalty to be imposed is an entirely separate proposition to be determined by the court as a matter of law on the basis of the penalty described by the statutes, end quote. And information, again, this is Utah, need only notify a defendant of a sentencing enhancement that the state intends to rely on if the defendant is convicted. The prosecution is not required to charge a sentencing enhancement. Accordingly, as the Angus court explained, an information that charged a crime that could involve a firearm enhancement would be sufficient, quote, if it alleges either one, that the defendant is being charged under the enhancement statute, or two, that a firearm was used in the commission of an offense charged in the information, end quote. The Utah Court of Appeals subsequently recognized in State v. Martinez that Angus, that's that case, quote, explicitly rejected, end quote, any argument that a sentencing enhancement must be specifically, quote, proven at the preliminary hearing, end quote. Rather, to satisfy due process, the charging information need only provide a defendant with notice that the state intends to rely on an enhancement at sentencing. Accordingly, the state was not required to prove, nor is the court required to bind defendant over on the two sentencing enhancements as they relate to counts 1 and 2. See Schroeder and Angus and Martinez. Regardless, they say, the evidence demonstrates probable cause to support both enhancements. Even if the state were required to demonstrate probable cause as to both sentencing enhancements, it did so. As demonstrated above, the evidence established probable cause to satisfy both the victim targeting and the violent offense in the presence of a child enhancements. See point 2E. For these reasons, the court should bind defendant over for trial on all counts as charged in the information. All right, there we go. And I believe that the defenses is due, I don't know if it's due next week. There is a date on that, and I might have said that not in the first video for this, but the video prior when I found out that the document had come out. I did have the date on that, but I don't have it off the top of my head. Thank you for being here. Let me know what you think. Please be nice to each other in the comments and don't get into a big old thing about whatever. We love freedom of speech. But the only question I'm asking here in this video is, do you think with a political, personal attribute that they should have said all that stuff about the religion? I don't know. It's a little unclear to me. But regardless, like the state said, it doesn't matter at this part. It doesn't matter at this part. I was concerned because I didn't think that they proved it, and it was very confusing with that 1102. But they're telling us now, the state's saying, we don't even have to worry about that now. Let's not get in a whole big hoopla about that. All right. Thanks for being here, and I will see you on the next one. I appreciate your support for the channel, the liking, the sharing, and all the love. Have a good rest of your day.